so it's 10:31. So I propose we start because we have a stellar panel with, I believe, most of the speakers of all conference. So thank you for the organizers for letting us this privilege to have this panel. I cannot believe how stellar panel we could bring you today. I'm Peter Kimpian from the Council of Europe, the Committee of Convention 108, and the topic of this panel is data transfer, and more specifically, the standardized contractual clauses, or how we prefer to call it in Strasbourg, the model contractual clauses that the Committee of Convention 108 prepared, or more precisely is being prepared, because the third module is due to be adopted in 2 weeks' time, probably on the 6th of June. This is a unique tool for us for many reasons, but I will let now the panel explain this to you, how they see it, what are their the opinion, the position, the takeaway, the plans regarding this transfer tool. And I will immediately give the floor for this purpose to Gonzalo from Uruguay, who is member of the Bureau of Committee of Convention 108, and also head of the legal department at the Digital Government Agency of Uruguay. Gonzalo, please.
Well, thank you, Peter. Hello, everyone. First of all, thanks to the Council of Europe for inviting me to participate in this panel with such distinguished colleagues. And I'm here to bring you a Latin American perspective on how we address contractual clauses in general and what we think about the model contractual clauses of the Convention as the first non-European member of Convention 108. Rudisha is online. She will tell me that she's the first non-European member of Convention 108+. But the truth is that it's a very important set of clauses for us. As you mentioned, I'm from Uruguay. It's a country in Latin America, as you all know. And I remember 6 years ago, we were here at CPDP, not in this venue, but at this conference, discussing the importance of Convention 108+ for countries that were outside of Europe. And at that time, we shared our insights regarding the documents that were provided in the Convention, regarding collaboration and cooperation. And I'm very happy to share insights 6 years later regarding this particular set of clauses, this particular instrument that the Convention is providing for safe and secure international data transfers. Well, as you mentioned, this is a set of, perhaps we will discuss it later, this is a set of 3 modules, 2 modules that were already adopted by the plenary, 1 is still to be adopted later. And I want to highlight the importance of the participation by members and observers in the drafting of these modules. And I also want to highlight, because it's for my convenience, the participation of a Latin American expert in the drafting, our colleague Pablo Palazzi, that also was the expert that collaborated in the drafting of another set of clauses that's very important for us, that is the clauses that by the Ibero-American Network on Data Protection. First, in a more national level on how we address the issue of contractual clauses, I might say that we have 3 approaches to contractual clauses in the DPA. First, we issued a resolution regarding a minimum content for clauses. We decided that it was important for especially SMEs and other companies that didn't have a power of negotiation to understand which is the minimum content that the unit will consider when assessing the compliance of the clauses with the national legislation. The second approach was to approve or pre-approve the set of clauses of the Ibero-American Network. And the third approach was to review clauses by large companies that were presented to the unit. We didn't give a pre-approval, but we reviewed those clauses, understood that they were compliant with the law, and it will be still require an authorization for the transfer, but that authorization will be by a fast-track proceeding. That is on a national level. On a regional level, we have the Ibero-American Network on Data Protection. I don't know if you are all familiar with the network, but it's a network that comprises data protection authorities from Ibero-America, from the Ibero-American region, also academia, international organization, both as members and as observers, and civil society. So it's a multi-stakeholder approach to data protection in the Ibero-American region. We issued a very important document in the Ibero-American Network that was the Ibero-American Network Standards on Data Protection. These standards are recommendations for Latin American countries on how they might modernize or create new laws on data protection. And the recommendation, but are also the aspiration, what we believe that a robust regime on data protection is for Latin America. These standards foresee the possibility of data transfers under contractual clauses that offer adequate safeguards to the data subjects. And it's in the framework of these standards that in the year 2021, 2022, the Ibero-American Network issued a set of clauses that were inspired in the EU MCCs, of course, but they are based on the standards that I already mentioned. Now, remember, these standards are recommendation. It's not a binding regulation, but anyway, we think that it's a robust, as I said, system. No? It's in this framework that the contractual clauses of the Ibero-American Network created a system that has a lot it's very similar to not only the SCCs of the EU, but also with the contractual clauses of the Council of Europe. We have two modules, controller to controller and controller to processor. Similarly, as we have in the Council of Europe, well, there's one more to come on the convention. These clauses have the certain provisions similar also to the ones that the Council of Europe is presenting. For example, the scope, the rights of the data subject, the security measures to be adopted, liability of controllers and processor, and the fact that they can be used both by private and public entities. That's also a very important issue about the contractual clauses of the Council of Europe. There are also some difference. They don't foresee arbitration. They don't foresee the possibility of selecting jurisdiction, that sort of things. So, well, to finish, because I'm out of time, just to highlight that these clauses are really as robust as the system in which they are based. And we believe that the clauses, both of the Iberican Network and of the Council of Europe, are based on a very robust system. And I'll leave it here and come back for the next question.
Thank you. Thank you so much. So you could hear an insider view, if I can say so. But Natasha, you are coming from an organization which is unifying the mobile ecosystem, GSMA. You are head of public policy and consumer affairs. What are your takes on data transfers internationally, and how do you see model contractual clauses or standard contractual clauses and all that?
Okay, thank you, Peter, and thank you very much for inviting us on this panel. It's my first time at CPDP, so thank you everyone who's made it here. There were so many other sessions going on. I'm pleased to see so many of you here. So for those of you who don't know GSMA, and that is probably rather a lot of you in the room, we're the Global Association for Mobile Operators. So we unite the 850 or more mobile network operators around the world. Essentially, whoever provides your mobile network, who provides your mobile service, will be a member of ours. And we also run a very large congress called the Mobile World Congress which takes place in Barcelona every year and has within it a ministerial program. And that is where much of our advocacy to governments and regulators and policymakers is made. We invite them from all over the world, including all of the new and the existing data protection authorities, or those who have supervisory role for data protection. We've been talking at that event and at many others and in our advocacy work on cross-border data flows for many years. It is super important to our industry. For the first sort of 8 years, I would say, we were talking about the importance of it and the economic value of it, and I'm really pleased that nowadays we can go straight into the mechanisms for it, because that seems to have been accepted across the world in terms of the value of allowing data to flow with protections appropriately applied. However, there's still really many challenges for our operators, those who are providing the mobile services, which in many parts of the world are the only internet connections that people can get. And those challenges come from the local laws, whether they have data protection laws in place yet, and if they are still working on them, and there are many countries who are looking still to modernize and incorporate clauses and mechanisms for cross-border data flows. That's still happening. But even where they are in place, there are often localization laws that still are requiring the data to be kept in country. There are overlaps in laws, so mobile operators will also have telecom licenses issued by the government, which can have contracts or clauses in there which require certain data to be held in country. So even with mechanisms within the law for data to pass to other countries with the appropriate controls, we have plenty of challenges there. And many countries we see today are focusing on adequacy first and very much focused on trying to get adequacy, particularly with the EU. But the timeline for these adequacy mechanisms, whichever ones or whichever part of the world you're looking on, is so long, it takes so long, and that's where standard or model contractual clauses really come into effect for our members. And I think you will all know the big mobile operators around the world, they're all using really SCCs, when we talk to them and when we talk to other large companies, what we hear are the challenges of so many different mechanisms around the world, of having to build up legal teams that are doing all the legal work on that. And that's where we see the complexities coming. But for GSMA, it's not just about the large operators who may have global operations and want to get those efficiencies by sharing the data across their footprints in national markets. It's also about the services that they enable in their countries for the small and medium enterprises. And I think that's where one of the main challenges comes from these MCCs or SCCs, is that it's the startups, it's the small SMEs who are driving the growth in many countries, particularly in countries in Africa where SMEs are the driving force of the economies. And those startups, particularly when they start, they can instantly become global if they have access to platforms, the big trading platforms. But how they apply SCCs or MCCs within their companies, how they understand that is the critical point. And I think the guidance that is required down at that level for companies is really what's going to make these mechanisms, when they are accepted in countries or even mutually recognized and become such a reality. It's the guidance and the help and support that the smaller organizations who can really benefit from their data passing across with protection that will really make the difference. Thank you.
Thank you so much. Very interesting. So that was the more of a business point of view or perspective. But if you allow me, I will jump to the next speaker. Thorsten will enlighten us of a very uncommon area, maybe for use and implementation. Thorsten, you are head of research unit, digital rights, surveillance, and democracy in Stiftung Neue Verantwortung. If I pronounce it well, I'm sorry. So how the MCCs are relevant in your work?
Thank you, Peter. Thank you all for coming to this panel. It's a pleasure to be here. Thanks for the invitation. that's the last time you need to pronounce that name. We're about to change it into an English. It's called interface. But that's not the reason why I'm on this panel. So we've already had some points being made about critical mechanisms in the law, and I want to shed something that keeps me perhaps awake at night sometimes. It's related to the governance of government access and oversight of that, because that too needs to have a foundation in law, and it has also, what is in the law need also be practiced properly, and so there might be a discrepancy in that. And if I were to find a good catchphrase to summarize my work, it would be possibly tied to what's in the modernized Convention 108 in Article 11. It says, you know, translated more or less, regardless of many of the rules and exemptions for data handling and data processes notwithstanding, this is without prejudice to the requirement that processing activities for national security and defense purposes are subject to independent and effective review and supervision. So that's Article 11 of the modernized convention. That's very, very important, and I would sign on to that phrase every single day because it's so important. I can relate that to the MCCs then, because if you look at the Module 1, you know, it's that supervisory authority in charge of ensuring data exporters' compliance with applicable laws as regards data transfers shall act as the competent supervisory authority. Now I'm stretching the language here, but competent supervisory authority. That asks for me is, what makes a supervisory authority competent? So what, you know, what do we need and expect from oversight bodies? What is the technological foundation that oversight bodies need to have to provide good oversight over government processing? You know, do oversight bodies need to have binding powers, as we learn from the conventions? You know, that if they come to realize that there is a mishap or a transgression, then they need to have the power to say no. And I wanted to relate that also, lastly, Peter, to clause 2022, because it says there, parties warrant that they have no reason to believe that laws and practices in the country of destination applicable to the processing by the data importer, including government access requirement, prevent the data importer from fulfilling its obligations. And of course, if I think about this, then I say, how might laws and practices look like that would prevent a data importer from fulfilling its obligation? And here you could say, well, there is a lot of national security legislation, even in our established democracies, where you might find considerable room for improvement, shall we say. So it's when it comes to the collection and processing by military intelligence. Notice Convention 108 Plus is the only binding instrument that relates to national processing of data by military and defense and national security. You don't find that elsewhere. So that in the national laws, however, this is a big construction site. Show me a country that has really regulated military agency processing of data. Data purchases, also related to the purchases from apps and the like. Binding powers I mentioned already, but also the systematic collection of open source intelligence. And lastly, Peter, when it comes to effective remedies, can non-nationals have effective remedy in the national setting? That's also a big issue, and I find relating back to the clause 2022 of Module 1 MCC, parties warrant that they have no reason to believe laws and practices in the country of destination make their job unfulfilling. So I find there are lots of question marks. I'm, of course, coming from civil society, and I want to put pressure on governments to make sure that when they preach and practice oversight, that this needs to be shown and documented. Thank you so much.
Thank you. Thank you so much. I'm turning now to the other regulator on the panel, Drudesha Madhub from Mauritius. It was already said, but I want to underline that Mauritius is the first country who ratified the modernized version of Convention 108 Plus outside of the Council of Europe member states. So your perspective, Drudesha, on MCCs and how this is important for you, for your country, and maybe for the African continent. Thank you, Drudesha.
Thank you, Peter. I'm very happy to be joining this panel today. I hope you can hear me properly.
Yes,
I hope you
we can.
Yes, okay. So, okay, thank you. So I will just switch off my video if you don't mind. Thank you. Yes, I believe the MCCs are very, very crucial for the African continent, for Mauritius and Africa in general. But before I move on to this specific African context, I would like to speak some words, what are really, what drives people to adopt MCCs from a country, domestic, regional, or even international level? What is indeed the benefit that we data controllers, the industry, data processors, state parties and non-state parties to the Convention 108 can gain from these MCCs? First of all, let me just tell you about what I think, my opinion about MCCs in general. Not only the CoE MCC, but all the MCCs from the Asian perspective, the CBPR perspective, the other Latin American perspectives. I think it's a real jigsaw puzzle that we have in front of us of MCCs, that is, from different parts of the world, where actually we need to bridge, as you said probably earlier, we need to bridge the similarities and the differences as well that exist among these different MCCs. And how do we really want to do this is actually this global approach that the CoE MCCs are proning. That's a very unique perspective that Convention 108 Plus is giving to the MCC community, the users of the MCCs, regarding the globalized approach, which is different from the regional perspectives of the different MCCs that we have from different continents and different parts of the world. I would also like to say, now coming to Mauritius, we have incorporated in our sections in our Data Protection Act, which is 13.4 and 36 of the Data Protection Act, the possibility of adopting contractual agreements between controllers and processors and controllers, which would allow my authority to authorize CoE MCCs or even EU SCCs to be recognized as part of the contractual framework within which cross-border data flows may be effected, and also the relationship between controllers and processors based on the written contract requirement. So actually this is fitting in our Mauritian context very well, and I believe that we're not going to face many huge challenges in getting the CoE MCCs on board when the Convention 108 Plus comes into force. Also, I would like to say that we have a very unique African perspective as well, which is the African Free Continental Trade Agreement, which is a contractual sort of requirement between state parties involving cross-border data flows. This AFCTA has actually 9 protocols which is connected to it, which regulates many different sectors like fintech, etc., from other sectors as well. And that is a very important document, a very important starting document for cross-border, for facilitating cross-border data flows across Africa. But unfortunately, the AFCTA does not have a similar sort of contractual requirement like the MCCs. And maybe the state parties, the African state parties to Convention 108 definitely will be able to benefit from the CoE MCCs should they not be part of, of this AFCTA agreement being, bringing a different perspective to the CoE MCCs. What I mean to say is that we need to be able to complementarize our approaches in having, in the African context, the AFCTA as well as where we can, the CoE MCCs being recognized by national and local data protection authorities like Mauritius, maybe other countries as well, which can use it as even non-state parties to the convention. So that would be a very nice way of marketing, between inverted commas, the CoE MCCs. But I would also like to say that the Malabo Convention in the African continent, as you are aware, actually has around, I think, more than 20 countries now which have ratified this Malabo Convention. Unfortunately, again, the Malabo Convention does not have, or maybe in the future, yet MCCs. And we would also like this approach to be extended to the African continent. And in doing so, why not join hands with the African Union? The CoE can also be a driver in getting CoE MCCs adopted in all its similarities through an African MCC by the African Union. And I would invite the CoE to join hands with AU and start discussions as to how we can make this approach harmonized and bring it in line with Convention 108. To conclude, I would also like to say that, we have so many MCCs, yet they are very important in their sector-specific and region-specific initiatives. But what we really need is, what we really needed, let's put it that way, is that one set of global and, MCCs like Convention 108 Plus is bringing into this context, so that we can really speak of, this global approach, making overarching regional perspectives. I would like to stop here, and I hope that I've been quite clear. It's not easy for me from Tokyo. I'm actually based in a very noisy place. Thank you very much.
Thank you. Thank you, Dudasha. Thank you also for your personal commitment for joining us from Tokyo. Coming to Europe, as we all ended here in Brussels, and turning to Estelle, I will not, of course, ask you about the Brussels effect, but maybe it's safe to say that we cannot discuss international data transfers without EU and European Commission and the tools and instruments. But this is not also a secret that we have been very closely working together on the CoE MCCs. So what are your take on that? Are you satisfied or happy? What are your plans regarding CoE MCCs? Thank you.
Thank you very much. Hi, everyone, and thank you for the invitation here today. Let me first congratulate the Council of Europe and everyone involved in indeed reaching this model contractual clause. From what we've heard from the fellow panelists before is already affirming the importance of the clause as a system, the importance of this development also for many countries. And before I go into those details on how indeed we've been moving from a step where data transfer tools around the world have been developing, and now we're entering a phase of how could we work all together to bridge those systems that have similarities, and what are the next steps on that. I do want to take a moment to acknowledge also the importance of model clause or standard control flow clause for transfer and for data protection. It's probably a given for many here in the room, but still, because there are many other transfer mechanisms used, sometimes those clauses, and even potentially because of their name, they're seen as contractual obligation. There is always the question of how does it apply to the individual, and how exactly is this relevant for data protection. But if you go look into at least the European experience from which I can speak of, the importance of those clauses is fundamental for data transfer. This is the most used tool for transfer. 85% of companies in Europe use them. 70% of them are SMEs, which we're going into. It's relevant for data protection. It's relevant also for competition in the market, because it allows companies that may not be fully savvy on data protection to be able to use an easily accessible and transparent tool and use it directly towards other operators. And it's a tool that benefits also people, because even though we as individuals may not be party to this contract, we have what is called third-party rights, where we can exercise our rights and seek redress towards it, which is really fundamental for any instrument. There is no secret that the data economy cannot function without data flow, and there is no safe data flow without data protection. And models like the clauses are here to be in detail and be a set invariable clauses that maintain this level of protection when data go outside of specific border. In that sense, seeing the development and the massive use of clauses by industry is something that is positive, and I do echo the point that were made also about ensuring that the clauses, when they are signed and used, also need to be enforced and checked. There is a lot of work and effort that has been put into ramping up the accountability system and the enforcement system, but as every system, improvement can always be done, and it's definitely an area that we need to be continue looking at, in particular in the areas of SCCs, because they are so used. It's also important for us to put in context the fact that those clauses are not just used by tech industry. We are a lot talking about those companies and the importance they have for the economy here at CPDP in particular, but those mechanisms are also often the entry point to data protection to sectors that don't do data protection on their day-to-day basis, the tourism industry, the health sector, and they use wide investment of data. So it's important that they have those mechanisms existing and ready to use so that this information can be protected. Internationally, we are seeing that this is also the fastest growing tool being developed. And Gonzalo was mentioning the SCCs from the Ibero-American network before, which are really great development. We're also seeing development happening at national level, those tools being adopted also in national country. There is those tools used in New Zealand, in the UK, ASEAN as a set of tools, and obviously the tools of the Council of Europe because we're here. And those developments are positive for convergence of mechanism, and how now that they are here and they exist, as was mentioned by the previous speaker, come the second phase of how do we make the system work together. We have seen from the use of our own clauses in Europe how other jurisdictions like Switzerland or the UK or New Zealand have recognized and adopted the EU clauses that hugely benefit then system because the same set of clauses can be used and recognized in others. And I do think there is opportunity also to work on bridging other clauses with other clauses in the future. We've done work also with ASEAN on creating guides for operators to understand the similarities and differences of our clauses. We are currently doing work also with the Ibero-American network to analyze the similarity and see how we can do those bridges. And very much so given the closeness also of the system between Europe and the Council of Europe, but the importance of the Council of Europe being far beyond Europe, it's the international standards. It is important, and it's a priority also for us to work on bridging and complementing those clauses. So this is, I think, the next phases that we'll have to look into all together and work on this. And here I do want to point already to the fact that, as usual, the data protection community is always looking ahead, because there is already work ongoing at the Global Privacy Assembly level, but also the G7 of the Data Protection Authority, although it's a more narrow set of actors, obviously, to already analyze the similarities and how of the different set of clauses that exist around the world, recognizing the important trends on the use of this clause, the importance of this clause, and the need we have to make them work together. Now, how does it kind of work exactly specifically? I think we're still in this point, but I do take as a positive note that everyone seems to be looking in the same direction of there is an interest for individual, there is an interest for economic operators to rely on this clause and to use them as a reliable, enforceable system. And with the multiplication of clauses going in the same direction, this is not a negative effect that there are multiple ones. This is actually an opportunity to work all together and advance a joint system.
Thank you. Thank you so much. Gary, you appear on the slide as the moderator, which I would not mind personally. It would give to the panel a very unique approach. But you are rather senior director, privacy and law enforcement requests at Apple. So how it is important, relevant, model contractual clauses for you, for your work in a company which put very high the flag of privacy and privacy protection, also in its business operations, which operate all over the world, also in not so friendly country or nice countries, but also some countries that have been, what could be characterized as troubled water. So what are these reflections or what you have at Apple on MCCs and specifically on CoE instruments?
Thank you very much, Peter. And I think the moderator language was taken from my appearance here last year, because unlike Natasha, I believe this is probably my 10th year of being at CPDP. And actually, as I was thinking of the panel in advance, I've been in the data protection world since 2006, and I've probably been on maybe 10 panels in that time discussing international data transfer. I would really hope that this might be the last one I'd be on. Not because I don't enjoy them, but in fact because perhaps we're getting closer to solving the problem by adopting a multilateral approach. So first of all, I wanted to congratulate the Council of Europe for bringing forward this initiative, but I also wanted to congratulate everybody in the room who've made a commitment to be here and to attend and have this conversation when, of course, there are many AI panels taking place, which no doubt maybe AI will solve the international data transfer issue. I doubt it, though, based on my experience over the years, but one should leave it open because apparently it will solve many issues. So as I think back over the last, 18 years in this world, and more particularly from an Apple perspective, we obviously do operate in, nearly 200 countries worldwide. What we have seen over the period since I've been with Apple, which is 2013 at this point, is initially, clearly, there was a dominance by Europe in terms of a focus on international data transfer and the requirements to move data from Europe outside. But now we've seen that, and perhaps that is the Brussels effect that Peter didn't want to speak about, we've seen that being replicated in many other countries worldwide. In many instances, that's replicated because countries do genuinely want to ensure that there is a high level of protection adopted to personal data in the exact same way as that's what drives the focus here in Europe. In other instances, and this is unfortunately the case, and I think Natasha averred to it in her comments, sometimes it's not for protection of personal data purposes, and I think Torsten was very much focusing on that in his comments as well. It is for data localization purposes, sometimes claimed to be for the protection of personal data reasons. But of course, I believe we all understand that in many circumstances, it's to afford certain governments an opportunity to be able to perhaps apply more pressure and access data. Now, in the main, we don't see that very often, but that is often the policy imperative that is driving the interest. And so therefore, when I see solutions come forward, such as that from the Council of Europe, which is genuinely trying to put on the table a solution which could then be adopted both by parties to the convention and by non-parties to the convention, I am very interested in that. I'm very interested in a solution that could be driven with the support of the European Commission, it sounded like to me, from Estelle's comments, as a solution that as a company, we could then potentially adopt one standard that we could apply globally if we could get a lot of people on board with that solution. Contrary to what we have to do today, which is, yes, Estelle is correct, we can use the same model contractual clauses for Europe, the UK, and Switzerland, but we cannot use those outside of those jurisdictions. We have to adapt them and use different ones. And while it's fantastic, it's jobs for lawyers on my team and external counsel lawyers in the many markets in which we operate, I'm not sure that is the best approach to ensuring protection of personal data. And the reason I brought my Mac here is because in one of the later questions, Peter has a question, and I realized I'd have to do some homework in order to respond to it. So I wanted to have the clauses in front of me as we do so. But as I read them, I do believe they form a very strong, solid foundation for protections for individuals, which is, after all, what this is all about, is putting in place strong protections for individuals that will then, once we've put those strong protections in place, allow personal data to flow freely, but only once those protections are in place for individuals, and only when the free flowing is the places where individuals will be able to avail of those protections. And I am very interested, therefore, in being able to support that. Now, Apple has been a big supporter of similar frameworks. We are signed up to the cross-border privacy rules in APAC. They tend sometimes to come in for some criticism because of oversight associated with them, but they do at least provide a strong foundation with at least a means for individuals to assert rights, and for companies such as Apple, who are signed up to them, to then have to respond to the assertion of those rights with some oversight, not from independent data protection authorities in all the instances, but in many instances it does. And I would certainly like the cross-border privacy rules to be at the table as we look at instruments of this nature. I also want to make sure that the OECD is part of this conversation because certainly, and I believe Torsten has worked in OECD work as well, back in 2010, 2011, I was part of a working group at the OECD, and I think there's been newer and better people on a subsequent working group, which has also been trying to bring forward common standards for data transfer. And I know Japan has also been pushing the issue strong as well. And perhaps we are now at the point which I had somewhat given up on some years ago, of there being sufficient players at the table to perhaps have an opportunity to come up with a common standard that will protect individuals' rights while at the same time then ensuring data can flow, and providing the kind of oversights that Torsten was referring to in relation to national security and military accesses to data, as we all have the same interests to make sure that that is all done extremely transparently and with proper judicial and legal oversight wherever that's happening. I don't know if that's my 7 minutes, Peter, but hopefully that conveys what we were looking to start the debate.
Yeah, thank you so much. So if you don't mind, well, of course, we cannot compete with machines on your remark on AI, of course. This is why maybe it would be a good time for us to open the floor for questions at that time, if you have. We have been listening to 6 speakers sharing lots of information, so maybe you have some question at this point. I have prepared some, but if panelists are ready, then we can take some from the floor at this stage. Yes, there's a gentleman over there, so can you please bring the mic? Thanks. I can bring.
Hello, I'm Stamos from European Investment Bank. We use these models, especially the EU standard contractual clauses, for doing business all over the world. The main problem is the enforcement of these clauses. Providers come to us, okay, we will sign them, no problem, but we have to complete the annexes, have dedicated technical and organizational measures, and also assess the legislation in the third country. And I think that we don't have to forget that these clauses cannot fill the lacunas in legislation. How CoE has taken this into account, considering also the Schrems case and need for this case-by-case analysis for these clauses to be enforceable.
Anyone on the panel would like to take this question? Okay. So I'm sorry. I was referring to
just to make sure we heard correctly, because the mic
yeah,
was a bit low. You were asking
here.
how the Council of Europe model clause took into account the requirement for government access and the Schrems decisions, right? Yeah.
Right. So there are specific clauses on that. We mentioned already clauses 22. That's the particular part that I invite you to look at if you are looking after the Schrems conditions. But I believe we are going even further to that. As a moderator, it's a bit antagonistic for me to speak about the clauses and their interpretation, but we believe that with Article 11, we bring much more to the case, and a much broader type of implementation that Gary and Thorsten also talked in a way about. With possible military application and access to data and national security, not only in the country of destination, but as standards for exchanging information among authorities. Thank you for the question. As anyone has, some, are they from there?
Thanks very much. Stephanie Perrin from Canada, representing Interledger Foundation. I'm very enthusiastic about the concept of a common standard, but I wondered, and the gentleman from Apple referred to it in his remarks, what you lose when a country that is not a signatory to the convention follows the standard. I understand that in the United States you've already got pretty good transparency in terms of military applications and access, better than many countries, I would say. But you do lose something without the enforcement of a country being signatory to the treaty. Nothing's ever perfect when it's transborder. I wondered if you could elaborate on what we're losing there. Or am I wrong?
I can start maybe on that. I think here again, it will all depend what we understand on the table as we come with the different, in this case, clauses by a common standard. From a government perspective, we're all bound also by our legal framework and our regulation. We cannot go lower than that, and we do not want to go lower than that, to be very clear. But we do see that similar mechanisms are being developed. And so there is still the question of like, okay, we may be not going to sign up all to the same model, but how can those models work together without lowering the standard? This is true for model clauses, but this is true for any other transfer mechanism. You know, we have similar tools, and there may be a way for them to work together, but for them to work together, there will be a reality that the adherence will have to be to the highest level of protection, because we cannot be telling to the individuals of one country, you had that level of rights, but when your data is going to go abroad, it's going to go lower. It's not always also, you know, when you look at the jurisdiction elsewhere, there are rights that exist that in some jurisdiction that do not exist in Europe. So it's in everyone's interest also to protect their own national acquis. But so as we see this trend of we're all going in the same direction, we have to build together a way to bridge our systems so they can function and offer a consistent degree of protection without lowering these. This is why I think the data flow conversation is going to continue for a little bit, because it's not such an easy system to do. But it's quite positive that we're all coming around the table and that the Council of Europe is coming also with those tools and those solutions, because they can offer a pace, and they can offer just the reality that, okay, we're all going there. We don't want to create patchwork, and they are already quite similar in a lot of points. In the point where we're not similar, how do we bridge that? For us, the reality is that you have to bridge it by the top of protection, and how do you make it also tangible and easy to use? Because at the end of the day, you also want to make sure that people can access their right easily, and that also, you know, company can rely on tools that are sustainable and that they will not create additional work for them to use. So it's a hard balance to find, but I think with all those clauses, we're getting there.
Yeah, thank you. Anyone else?
Well, I read clause 26 because, as I say, I can prepare to do homework as affording some choices in relation to the form and jurisdiction. And the data subjects, as I read clause 26.2, may bring legal proceedings against the exporter and or the importer in their country of their own habitual residence, which is a big deal for companies to sign up to, for anybody that does. Probably easier for the Apples of this world than a smaller company, because managing litigation in any country of habitual residence could in fact be quite costly. We might be better placed to be able to manage that than others. So that's just something to be thought through, just taking account of some of the points that both Estelle and Natasha were making, which is that sometimes there's a lot of focus on the big companies, and I'm here as a big company, but the clauses are mainly used by smaller companies because they simply don't have the means to meet all the different patchwork legal requirements for transfer, and the clauses can be very helpful in that regard.
Yeah, there are several parts, level of reflections at the Council of Europe also on these issues. So there is the public international law, which we believe that there is going to be considerable changes with the entry into force of the modernized Convention 108 and the evaluation and follow-up mechanism that can bring to the table, and also the implementation of this convention. And there is also the way, the path that Gary mentioned, that is already in the text, and how to align all these enforcement mechanisms with private international law and the existing mechanism of conflict resolution, dispute resolution, and these very well established mechanism. But let me turn to our speakers for the remaining part of our panel. So Judesha, you have been carefully listening online. So any reflection from your side, or something that can be relevant for regulatory perspective in Mauritius, which is a very open and active economy, and also a very much driving force for many developments in the continent, I believe. Judesha, are you with us? Maybe.
Yes.
Okay.
Yes. Hello? Can
yes,
I speak?
we
Hello?
can.
Okay.
We can hear you now.
Okay, thank you. Thank you very much, Peter. Sorry. I wanted to react a little bit to the debate. I think it's also in line with what Mauritius has been doing. You see, the two main aspects in relation to having, good principles in general is actually having a good law, a robust law, and coupled with, a very good data protection authority, and effective and proactive data protection authority. So these two elements are the basic essentials in making any data protection principle work across any jurisdiction and the globe. If we don't have these two elements, I think data protection is going to suffer a lot wherever we are in the world. And this element, sometimes we believe that some countries are more advanced, more developed countries, have more developed principles in data protection, whereas compared to other less developed jurisdictions having less developed data protection principles. But this is where Convention 108 for Mauritius has been a key enabler, in the sense that because of these differences, ratifying Convention 108 Plus has brought, I believe, Mauritius to the international level of compliance. And that is an element that I would like to really emphasize on for other countries as well, not only for Mauritius, not only for Africa, but also other countries in Europe or in Latin America who have not ratified or who is not a party to this convention, to be able to consider the importance of having what we know already, this unique and legally binding one and only convention on data protection. Should we go in that direction of aligning ourselves to Convention 108 Plus, actually we are going ahead of certain differences and certain lacunas and weaknesses that we find in regional instruments. Also, being the latest and the newest kid on the block, Convention 108 Plus is actually bringing elements that have, in the past, we have seen the pros and cons, and bringing some solutions to that. If you look at the MCCs very well, it's very detailed, but in a simple way. That is, bringing all the principles in the contractual clauses, but in a simple way, which makes enforcement practical. And this is what we need in MCCs. And to be very honest, we know that some MCCs are also quite complicated, some are quite simple, and not all of them actually address all the issues that need to be addressed. I'm not saying the MCCs from CoE are perfect, but I'm saying that they are actually meeting some of the current requirements, and that is very important for us to consider. And one last aspect is that regarding choice of jurisdiction, as you know, it is the data exporter applicable law, which is the rule, but you also have arbitration. You also have amicable resolution of disputes. And that is something that we should also consider. Thank you.
Thank you. Thank you, Natasha. Natasha, you are also been listening to these conversations and some of the considerations. So what are specifically the perspective on transfer mechanism at the GSMA in relation with your engagement with mobile operator members and stakeholders?
Thank you. Well, I think it's rare that I'm sitting on a panel and everybody is saying the same things, and I find myself agreeing with everybody. So I think that's really positive for cross-border data flows. I think from GSMA, we very much think about it globally and for our members across different markets. And we talk a lot about regional harmonization and interoperability between these, but actually a lot of the trade flows are cultural as well, between countries with similar languages or cultural ties that may not be within the same region. And I think the reference that we had before of jigsaw puzzles or patchworks, or I've even heard on other forums people talking about the spaghetti bowl of mechanisms and these different ones. I think that's what's the most important for us. It's making these interoperable, having the mutual recognition by countries. And, Dridesha said it, in emerging economies where most of our work is done on these types of issues, it's about having a data protection law that's robust in place and an authority who is, resourced and competent and can deal with the issues. But I think the worry is the timeline for this. There's an urgency about getting these mechanisms to work across borders quicker, to get these recognition of different schemes. If I'm an operator working or a company in one country and I'm using, I don't know, standard contractual clauses from, I don't know, New Zealand, then why can't it also be recognized in Brazil, in other parts in Africa as well? We just need this to happen. And the sooner we can get that urgency out there on the ground in implementation, the better, because what we want is the organization's employees to be working on things like privacy by design, safety by design, children's privacy, and really adopting accountability principles into their privacy programs and not spending or building up legal teams as some of the large companies have had to do. So for me, it's all about urgency. Thank you.
Thank you so much. So I think, well, we are running out of time, but I think we still have time for our last 1-minute reflections. Torsten, do you think that national security agencies could use those MCCs and perhaps their oversight authorities can approve or endorse them in the future?
Okay, that's a very interesting question. Try to cover it a little bit. We're talking about the heart of secrecy when we're talking about intelligence cooperation. And intelligence cooperation is not just transfer of data, but has a lot of joint databases and the like. But you mentioned AI might solve the transatlantic data puzzle. Now, if you would put a clause to the member state party saying the data importer agrees to submit itself to the jurisdiction and to cooperate with competent supervisory authorities of that state and to also submit to review and audits of that state 21.2 clause, they may say the system was hallucinating because they wouldn't submit to that. I don't think we are there yet. I think I see lots of good things in the model clauses, and I compare with national legislations. For instance, in Germany, we have few countries in the world that have adopted rules on intelligence cooperation and for sharing data, but it's a unitary, and you can have the best law in the world if someone else doesn't apply or use it, then that falls down to pieces. So at the moment, we have the duty of the German government to seek rule of law assurance and to make sure that this and that happens, but it's not bound with anything on the other side. So, and I haven't seen anything in the open. I haven't seen documentation of the kind. Obviously, as I mentioned, it's in the heart of secrecy, so there needs to be patience. There needs to be also concerns, right concerns for government secrecy. Of course there are, but I see this development as very promising in a sense that it flags a number of issues that come up and that need to be regulated and ideally have an international agreement of that kind. But if you put in a clause like this where you submit to the authority of a foreign data protection authority, that could happen in very few circles of friends, and maybe that's the one you start with. But I'm cautiously optimistic. Thank you.
Thank you so much. Gary, do you think, as a last point, that these clauses are strong enough, specifically with regard to data security and encryption type of matters, and reference to Article 11 is enough, or?
Yeah, I've studied them, Peter. I actually have quite a simple solution to the problem. The simple solution to the problem is that you, first of all, don't collect personal data in the first instance if you can avoid it, because then you don't have the issue. Secondly, if you are going to collect it in a way that's not identifiable. Pseudonymization is not that. I would not claim that. It needs to be not linked. And then if you do need to collect it, subject it to end-to-end encryption. Apple has many solutions. Other companies have many solutions. I think what's interesting in that debate, and none of us should be naive here, gathered in a kind of, as Natasha pointed out, all agreeing with each other. Not everybody agrees with end-to-end encryption. We are entering and are continuing to be in a space whereby the concept of end-to-end encryption is not agreed with, including by governments right here in Europe. And we need, as a privacy community, to make sure that we retain our resolve to focus on ensuring that we can provide the highest possible protection to data. Because if we cannot, then that data will be open to abuse both by companies such as Apple, because once we can access it, or nefarious actors. And we feel very strongly about that one. And I'm hoping that when we have clauses of this nature, they will provide a strong support for companies who want to subject data to end-to-end encryption.
Thank you. That's good news. Estelle, any final thoughts from the Commission side?
So there is still a lot of work to do on getting all those clauses working together. That was one point that I think I take as a takeaway. I think also, just highlighting, we haven't discussed it in too much detail in this panel, but the importance, obviously, of putting always those clauses and those mechanisms into context. Those mechanisms exist for the contextual purpose of transfer, but the issue of data minimization, data security, promotion of encryption, addressing government access to data, they are core to any data protection instrument, including transfer instrument, and that's an area where we all collectively have to continue working. They are principles that are widely shared by data protection laws around the world and in the convention. So I'll just share a message that is the usual message, but inviting governments in our region, but also around the world, to ratify Convention 108+, to look into those clauses, and to also sign up to the OECD Declaration on Government Access to Data, because those documents are really a key steps for us to get to the common place, to be having standards on which we can agree and ensure that when data is transferred, no matter where, there is a level of protection that we agree on.
final word, Gonzalo, as a bureau member.
One word.
One word, we are running out of time, so that's
No,
the challenge.
I just agree
One
with
sentence, maybe.
One sentence. Oh no, I just agree with everyone. With what everyone said. In fact, it's important. I think, and Estelle mentioned it. If we are to tackle this jigsaw situation between different model contractual clauses or clauses, we have to understand what we are talking about. So the important work of understanding and seeing the difference and the commonalities. There's an ongoing work on the GPA on that issue in a working group. So that's very important. And well, regarding these clauses, encourage everyone to accede to Convention 108 Plus, and those who don't do that understand that these clauses also provide, even for non-parties, a very high level of protection for the subjects. And with that, I close.
Thank you. Thank you so much. I thank you for your patience, and thank you for listening to us. I invite you to give a round of applause for our excellent panelists. Thank you so much. Thank you.